In the matter of Regency Villas Title Ltd and others versus Diamond Resorts Europe Limited and others.
Lord Briggs will summarise the reasons for the judgment.
The main question in this appeal is whether a right to use recreational and sporting facilities on neighbouring land can exist as an easement. An easement is a type of property right annexed to the ownership of land, usually called the dominant tenement, to do something on neighbouring land, usually called the servient tenement. Its unique feature is that both the benefit and the burden of it run with the land, so that any owner of the dominant tenement has the benefit of it, and any owner of the servient tenant is bound by it. Typical examples are a right of way, which enables the dominant owners and their visitors to gain access to their land across neighbouring land from the public highway, and a right of drainage, enabling their wastewater to pass over neighbouring land to a public sewer. It was for a long time a contentious question whether a right merely to walk over neighbouring land, such as an ornamental garden, for the sheer enjoyment of it, rather than as a means of access to other land, could ever be an easement. Roman lawyers said no. It was only what they called a jus spatiandi, a right to wander. Some English judges called it a mere right of recreation and amusement, which could not be an easement because it did not serve or accommodate neighbouring land. It merely gave pleasure to the walkers, but had nothing to do with their enjoyment of their own land. In the famous case of Re Ellenborough Park, the Court of Appeal decided in 1956 that a right to use a communal private garden square for recreation could be granted as an easement to the owners of townhouses built mainly around the square. The court said that such a right did serve or accommodate each townhouse because it provided it with a garden, the use of which enhanced the normal use and enjoyment of a townhouse. In the present case, the attempt to create a recreational easement was much more ambitious. Broome Park is a 17th century stately home with a large surrounding park. It was once the home of Lord Kitchener of Khartoum. In the 1970s, it was redeveloped as a country club with a complex of leisure and sporting facilities, both within the mansion house itself and in a large part of the surrounding grounds. The attractions included indoor facilities for squash, billiards and gymnastics, some within the mansion house itself, and outdoor facilities for riding, tennis and swimming. The complex included an ornamental garden and an 18-hole championship golf course. The neighbouring land, now called Regency Villas, is the second of 3 timeshare developments, designed and built so that its timeshare occupants could make use of the country club and leisure complex. The first development lay within the upper floors of the mansion house itself. The rights of those timeshare owners were provided within a leasehold structure. But the occupants of the Regency Villas timeshare development were, in 1981, given rights to use the leisure and sporting facilities in the Broome Park complex by what was, if the law allows it, intended to be an easement or easements. It had been thought by the developers of Broome Park that the substantial ongoing costs of the maintenance and repair of the leisure complex would be met by payment from users drawn from members of the public, so that the timeshare owners could have the free use of the facilities. This proved to be a miscalculation. After unsuccessful attempts to reach agreement for sharing those costs among the timeshare owners, the new owners of Broome Park, who are the appellants in this court, took the position that the Regency Villas timeshare owners had no rights of use of any kind and would only be permitted continued use of the leisure complex if they paid for doing so. That led directly to the present claim by the Regency Villas timeshare owners that they enjoyed such rights in the nature of a recreational and sporting easement. Both the trial judge, the late Judge Pearl, Queen's Counsel, and the Court of Appeal decided the important easement question in their favour, although they disagreed about whether the easement extended to all facilities within the complex from time to time, or only to those which existed at the time when the easement was granted, in the location where they then existed. The judge thought the former, the Court of Appeal thought the latter. This mattered in particular because the original outdoor swimming pool had been filled in and an indoor pool built within the mansion house to replace it. The Court of Appeal held that the new swimming pool and other facilities constructed within the Mansion House long after 1981 fell outside the terms of the grant. The appellants argued in this court that the rights apparently granted in 1981 were incapable of being easements, so that they were not bound by them. They say that the recreational rights do not accommodate the dominant tenement, because they are for enjoyment in their own right, and that they involve active maintenance and operation by them as owners of the servient tenement, so that they are incompatible with easements as recognized by the law. The Regency Villas owners, as respondents, sought to uphold the courts below on that question, and also by a cross-appeal to reinstate the judge's interpretation of the extent of the rights granted. This appeal has given the Supreme Court its first ever opportunity to consider the question whether purely recreational rights can be easements, with all the durability during successive ownership of the dominant and servient tenements which an easement confers. Not merely have we had to consider whether the Ellenborough Park case was correctly decided, but also whether the principle which it established can be extended beyond a town garden square to a full sporting and leisure complex in the country with its greater running costs and operational responsibilities. We have decided both those questions in the affirmative. All of us considered that the Ellenborough Park case was rightly decided on its own more limited facts. The majority also consider that sporting and recreational facilities of the present type do accommodate a dominant tenement which consists of timeshare units, because typically timeshare owners use their units for holidays, during which sport and recreation are likely to be valuable nearby facilities. The fact that the free use of the facilities in the leisure complex may be a main reason for buying the timeshare units supports rather than detracts from the classification of the rights as an easement. Lord Carnworth considers that it would be wrong to extend the Ellenborough Park principle to a full leisure complex because the substance of the right granted is to use facilities provided by the servient owner rather than just to use land, and because of the burdens of active participation thereby thrown upon the servient owner. All members of the court agree that an easement does not in law require more than the passive concurrence of the servient owners in the enjoyment of the rights upon their land by the dominant owners. But the majority consider that the question whether the enjoyment of these rights required more than passive concurrence of the owners of Broome Park is a question of fact. Both the judge and the Court of Appeal decided that sufficient use, although not full use, could be made of the sporting and leisure facilities even if the servient owner discontinued maintenance of them. The Regency Villas timeshare owners could still step in, mow the greens, supply water to the pool, and provide equipment for the tennis and squash courts. The majority in this court see no reason to disturb those concurrent findings of fact. Finally, the law should now, perhaps more clearly than it has in the past, recognize the importance of recreation and sport as potentially the subject matter of an easement, and lend its aid to the creation of such rights as easements where the parties so intended, and where the legal conditions for an easement are satisfied, as they are in this case. On the question of interpretation about which the judge and the Court of Appeal differed, this court, by a majority, prefers the conclusion of the judge. It is more in accordance with common sense and the intention reasonably to be derived from the words of the grant read in their context. Lord Carnworth prefers the view of the Court of Appeal. The result is that the appeal is dismissed and the cross-appeal allowed.